All right. Hello. Good afternoon, everybody. My name is Kevin. I'm the training coordinator with ASFPM. I'd like to welcome you to our presentation today. We're going to be talking about no adverse impact. We're going to be talking about it from a bit of a legal perspective. But before we get into the topic itself, I've got a few sort of administrative announcements to go through before we get started. So the first thing I want to just mention today, because we've got a sizable group here, is webinar participation. And so one thing you may notice pretty early on is that all lines are going to be muted, so we won't be able to have that sort of verbal exchange just given the sheer size of the group. But we do want to take any questions or any comments you may have about this material. So in order to do that, there's a Q&A feature within the Zoom interface here. Any questions or comments, just go ahead and drop it into the Q&A, and we'll take as many of those as we can, kind of as time allows. We may sprinkle a few questions throughout, but we're going to save the bulk of them for the end. So if you ask something early on and you don't hear it addressed, please just try to be patient. Like I said, we'll get through as many questions as we can at the very end. So that's going to be the way we participate today. Other things I want to let you know: we're scheduled for 90 minutes here. I think we're going to take up pretty much the majority of that time, but we'll try to keep things to 90 minutes and not go over too much. We are recording this event, so if we go too fast, or you just want to reference this later on, if you're taking notes and maybe you want to see something again, we do have the recording, so we're going to be making that available in some form or fashion post-event. So don't worry, we do have a recording going here. A note on professional credit: if you're a CFM or an AICP for that matter, this event is eligible for 1.5 credits toward each of those certifications. So just wanted to let you know that you are eligible to receive those credits so long as you're on and participating for the duration here. If you're in a group setting, unfortunately, we're not able to issue credits to all members of a group watching from one machine. So just a note about that. If you are a CFM, a national level CFM, ASFPM will be applying those credits to your records automatically. It's going to take us about a week to do that, so try to be patient there. We also will be following up with certificates of attendance. If you stick with us for the duration today and earn a certificate of attendance, that is going to be emailed out to you as a PDF attachment from me. And again, you'll get your CECs. If the recording is ready, then we'll be sending that out. Any other promised follow-up from today, whether it's links or resources or what have you, that'll be sent to you via email. Please allow for a week for us to process everything and turn that around. So enough with the sort of admin announcements, but to get into the topic at hand today, I want to introduce Chad Bergenis, who's our executive director here at ASFPM, and he's going to tell you all a little bit more about what to expect today. Chad, take it away.
All right, thank you very much, Kevin, and welcome to all of you joining us from all over the country. My name is Chad Bergenis. I'm ASFPM Executive Director, and I couldn't be more excited to be introducing this webinar. And just a little anecdote from early in my professional career. When I first became acquainted with the Association of State Floodplain Managers, I became aware of some of the resources that they were producing. And when I was a local floodplain manager, we had a particularly difficult floodplain violation I was dealing with. And at the time, I looked up online and found some legal resources that the association had developed. My prosecuting attorney had never prosecuted a floodplain violation, much less a land use case. And using those resources that ASFPM developed, we were able to not only successfully prosecute the floodplain violation, but essentially remedy the situation so that flood losses didn't increase and that they didn't continue. Over 30 years, ASFPM has been providing legal resources to the practitioner community in order to help floodplain managers do their jobs better. And this new resource that we have just developed, and this webinar, a legal examination of no adverse impact floodplain management stewardship, is just the next chapter of those resources. I couldn't be more excited to have a wonderful team, including the co-authors of this publication that'll be presenting today. Today we have Jerry Murphy, again, one of the co-authors of and instructor in this webinar. Jerry Murphy is a state specialized program agent for the Program for Resource Efficient Communities at the University of Florida. His work and research involving land use planning and control law, community-based planning and code regulation drafting, floodplain management, growth and infrastructure finance, post-disaster redevelopment planning, and community resilience and sustainability. He currently works with local governments and regional planning councils to assemble teams of expert faculty, researchers, and student assistants to help craft planning approaches and strategies to climate change. Jerry is also the co-chair of ASFPM's Higher Education Committee. Second, we have Thomas Rupert, Esquire, who serves as the director of the Virginia Coastal Resilience Collaborative, an initiative of William and Mary that builds upon the foundation established by the Virginia Coastal Policy Clinic, which operated out of William and Mary's Law School. The VCRC continues to work in partnerships of the Virginia Coastal Policy Clinic to seeks to expand the network of resilience collaborators in Virginia. In addition to being a co-author of our latest publication, Thomas is also a co-chair of ASFPM's Higher Education Committee. We also have with us Terry Turner, AICP and CFM, who's the owner and principal of Halo Strategic Planning, LLC. Ms. Turner has worked for city and county government for over 28 years as a planner, floodplain manager, and hazard mitigation specialist. And Terry serves as the No Adverse Impacts Committee co-chair for ASFPM. And while not presenting, I didn't want to pass the opportunity to also recognize Janet Thigpen, who is a flood mitigation specialist at the Southern Tier Central Regional Planning and Development Board. Ms. Thigpen has implemented a regional flood assistance program since 1996, providing the three-county Southern Tier Central region of New York State with technical and planning assistance for diverse flood damage prevention activities. And Janet is the co-chair of ASFPM's No Adverse Impact Committee, and also was a heavy collaborator in the development of our latest publication. Finally, before I turn it over to Terry to start the program, I'd like to mention that if you do go to ASFPM's website, www.floods.org, you will find a wealth of information. But under the ASFPM Library tab, you will notice that we have a library or a special collections, and one of those is of legal resources. So in addition to our latest publication, which you'll hear a lot more about today, we also have some of the other legal resources that may be of interest. But for now, let's get on with the program. And Terry, I turn it over to you.
Thank you so much, Chad. And I'm going to come off video if my computer will cooperate with me, so you can see these great slides we've developed for y'all today. So what do we mean by no adverse impact floodplain stewardship? And why are we using the concept? It's a framework for collection of legal resources related to floodplain management. Next slide. So no adverse impact is a philosophy, a concept, a strategy, if you would, that strives to ensure that we don't harm one another with negative impacts caused by development or other development-related activities. So what you see before you on the screen is a working definition of no adverse impact. NAI is an approach that ensures that the actions of a community or property owner don't have adverse impacts on the rights of others. The rights that we want to protect and what we're talking about here include property rights, public safety, water quality, the need for public services, just to mention a few of those important impact areas. Next slide. More recently, the NAI folks are using the term floodplain stewardship to shift how we think about floodplain management. It's important to manage human activities in the floodplain, but we also want to think holistically about the natural systems and natural functions of floodplains. So this is how we are defining floodplain stewardship: caring for and protecting the beneficial biologic and hydrologic functions of areas where the risk of flooding is expected, while managing human uses to minimize the potential for adverse impacts and flood damage. I don't know about you, but I like the shift in thought process from managing floodplains and floods to being a good steward of areas that are at risk for flood. Next slide. The reason that we need the NAI approach in the first place is because flood damages are escalating nationwide, and the minimum federal standards established under the NFIP aren't adequate to prevent even more damage to property in coming months and in coming years. Even if we perfectly implement the NFIP standards, and a lot of communities are doing that, flood damages would continue to increase. This is because current approaches deal primarily with how to build in the floodplain rather than how to minimize future flood impacts. Current NFIP standards are designed to reduce the vulnerability of new construction to rising water damage during a flood event. But what about the community?
Hey, everybody, just bear with us for a moment. It looks like Terry is having a little trouble with her connection. We'll try to get her back. Usually this just takes a few seconds. Okay, so in the meantime, while we're working to get Terry back, I don't know, Janet, did you want to make any comments in general? Or perhaps we can just move on to our next section. Let me know what you think.
I can keep going with the presentation until Terry gets back.
Okay. Yeah, why don't we do that?
So we need NAI because the flood damages are escalating, and the current approaches aren't dealing with keeping people out of the floodplain, designed primarily to address how we build in the floodplain. And they're also not protecting natural functions of the floodplains. So next slide. So we want to fulfill the community's obligations to health, safety, and welfare. And here are some of the limitations of NFIP that maybe fall short of that. They rely on, there are few restrictions on where to build, no protection of floodplains and wetlands or other sensitive areas, no limits on siting of critical facilities, and fill is allowed in the floodplain where it can actually increase flood hazards because it displaces water and diverts flood flows onto other properties. This isn't to say that NFIP standards are bad, but they're inadequate. Remember, NFIP is established as an insurance program, not a land management program. And the standards are designed to protect insurable development, mostly buildings. So the protection it provides for people, for communities and natural features, those things are secondary. But quite frankly, it's the only tool that some communities are using to regulate floodplains. So NAI approaches encourages more additional tools to supplement the NFIP requirements. So the next slide. This is just the basics of floodplain management. The FEMA flood insurance rate maps show the boundaries of the area that's expected to have a 1% or greater probability of flooding in any year, special flood hazard area. Development is allowed within this high-risk floodplain, requires a permit from the municipality, and needs to comply with standards such as the building elevation. And those standards are intended to protect the permitted project from water damage when the 1% probability flood occurs. And if the adjacent area next to the creek or river is designated as a floodway, then it's reserved to convey floodwater, and an engineering analysis is required. But the fringe areas, one of the techniques that can be used to elevate development is to bring in fill, as was done in this image, to put that factory there. So the fill raises the new development above the prior flood height, but it changes the whole dynamics of the floodplain and stream system. That water that used to spread out on that floodplain has to go somewhere. So it'll get deeper and it'll probably get faster. So the next slide. So we have a higher flood level. Oops, go back one. We have a higher flood level. It's affecting more properties, even affecting the new property that was built on that fill. There may also be erosion problems and upstream and downstream issues resulting from this. This is just part of the adverse impacts. There are also impacts to emergency response, community impacts when a factory major employer has to close because of flooding. So the next slide. So NAI doesn't mean no development in the floodplain. I'm not saying the community in that last example should deny the permit, but you need to do some creative thinking to develop strategies for mitigating those adverse impacts. That case, the community might buy out the properties that would be flooded. If the newly flooded areas are undeveloped, then maybe it's a good place for a park. Revised regulations to require a higher level of flood protection when, if it is developed. Next slide. NAI is locally driven. Impacts of development are identified and then evaluated, not only on the project site, but throughout the entire watershed. And then those impacts are accounted for using mitigation measures in order to reduce or to eliminate the potential harm to others. So no adverse impact transforms the concept of floodplain management to one of flood risk reduction and floodplain stewardship. Next slide. So NAI is big picture thinking. It doesn't just address the single property that's being developed at this time, but any and all properties that'll be affected by that development. It actually brings them into consideration during the planning process. Next slide. So you might be thinking that you'd really like to get your hands on that NAI model ordinance, but there is no standard set of regulations, no template that a community can adopt. NAI is a community-centric approach. It needs to take into account all of the unique features that exist within each community. So it's not a one-size-fits-all principle. It's about what works in this community, and it's driven by what this community needs and what they desire in order to reduce flood losses, reduce the risk, protect health, safety, and welfare throughout that community. Next. So this is NAI is not just about land use regulations and development approvals. This is a list of the different community activities that can incorporate this NAI approach. And each of these 7 building blocks, in the toolkit, we've developed how-to guides to help with creative thinking about approaching these different areas of community activities and incorporating NAI into those ongoing programs. Next slide. NAI is a win-win philosophy. It's a good neighbor policy, provides a foundation and the tools to help communities fulfill their responsibilities to protect health, safety, and welfare. Includes protecting the community's infrastructure, their land, and their citizenry from flood hazards. and it's legally sound. Next slide. And this is the link and the table of contents for the new legal guide that we've developed. And with that, I will turn things over to Jerry for some legal perspective on how it's legally sound.
Good afternoon, everybody. Well, we wouldn't be lawyers without beginning with a good caveat, so here it is. Also, keep in mind that we are discussing floodplain management and law generally across the whole United States. While there are broad brush similarities in many areas of the law across the states, ultimately tort law, property law, and water law are inherently creatures of state law, so variations do exist. Thus, this caveat. Next. So a brief overview of what we'll cover in the legal section of this webinar. The future of flooding looks less like the past, and thus looking backwards to plan for the future is no longer enough. Floodplain management has historically approached flooding through flood control, which is not big picture approach to Earth's changing climates. There is a common law and case law underpinning for a no adverse impact approach to stewarding the floodplain, and valuable prizes, the NAI Legal Guide resource. Next slide. Climate change related flooding is getting more and more expensive. Next slide. Billion-dollar disasters by the numbers. In 1980, NOAA started tracking billion-dollar disasters. In 2020 alone, there were $22 billion disasters, 7 of which were tropical cyclones. This slide says the most on record, but this slide is a few years old. From 1980 to 2020, there were $285 billion disasters in the United States, on average 7 per year. And that average has increased to 15 per year since 2015. At least one of each of the 50 states, not all related to flooding, but flooding is our most common and costliest disaster, has had one of these billion-dollar disasters. And of the $285 billion disasters in the period, 119 of them occurred after 2010. The total cost of those $285 billion disasters was $1.875 trillion. And Texas is the winner with $124 billion disasters since 1980, the most of any state, because everything's bigger in Texas. Next slide. So Gilbert White, the father of floodplain management, or what we prefer to call floodplain stewardship, we think stewardship is more amenable to the no adverse impacts approach to floodplains. Management, to me, indicates control. And I believe the idea of control when it comes to water, particularly floodwaters, is too often and maybe always a false perception. That perception's proven false every time an engineering solution fails. But both control and management are deeply embedded in our lexicon. Florida is divided into 5 water management districts. There are flood control districts and structures throughout the United States. Still, I prefer the implicit humility in the term stewardship, as it indicates more of a cooperative partnership with the natural world. Next slide. More in keeping with Ian McHarg's design with nature approach. In a nutshell, that involves a layering of geospatial data to analyze how to best fit human interventions into the native landscape. This approach was digitally memorialized with Geographic Information Systems, or GIS. A GIS, or geospatial analysis and modeling tool on which we increasingly rely. And lately, it is prominently featured in future flooding vulnerability assessments. Next slide. Gilbert White thought there were approaches to stewarding that respect floodplains for the natural beneficial functions floodplains provide, not as a natural common enemy to be controlled. Next slide. And the congressional approach to flooding, the National Flood Insurance Program, or the NFIP. This covers flood insurance, floodplain regulations, risk mapping, and flood hazard mitigation. The 3- or 4-legged stool, depending on who's describing the NFIP. Regardless, the NFIP takes in far fewer dollars in premiums than it pays out in claims. Currently, at least $22 billion in debt. Not a sound business model. And because the NFIP is a federal program, it's up to Congress to make major modifications. And while recent congressional actions have been rare, they have increasingly been moving in the direction of higher NFIP premiums, particularly for coastal properties. So let's answer the question. Next slide. There's the floodplain. Now, where do we go from here? Answer: away. Stay on higher ground. First of all, floodplain equals flooding. Don't build people's housing in the floodplain. But if we do, as we do, we should anticipate, expect, and prepare for flooding. And as extreme weather events increase with climate change, anticipate, expect, and prepare for more extreme flooding. Management or stewardship of the floodplain has become and is increasingly a major function of local government. And when a flood disaster occurs, we often look to the state and federal government and to an acronym, FEMA. But a more comprehensive perspective includes concerns for liability. Local government doesn't want to be liable for infringing on private property rights. There are rights and responsibilities that accompany our civil and social notions of property. The responsibility part, call it duty, mostly fades from contemporary conversation. Neither do we want to be liable for damages to property, private or public, caused by flooding. More and more accurate climate science and flood data and projections are available to local governments, and with more data comes more granular foreseeability, predictability, responsibility, and potential liability. Comes now the Army Corps of Engineers with an atlas documenting successful engineering with nature, harkening back to McHarg's Design with Nature. And there are new publications every day, it seems, addressing the land-water dynamic and how it is exacerbated by climate change. The law evolves too. Next slide. So let's discuss these legal aspects of floodplain management and regulation, beginning with the common law. The majority of states in the United States have aspects of common law or judge-made law carried forward from England and the United Kingdom during the colonial era. Common law refers to the part of English law derived from custom and judicial precedent rather than legislative statutes and administrative regulations. Common law is contrasted with statutory law. It's that body of English law adopted and modified separately by the different states of the United States and by the federal government. Flood liability lawsuits are commonly based upon one of 4 causes of action: negligence, nuisance, trespass, and the law of surface water. Next slide. So with that introduction, let's jump into some of the legal aspects of floodplain stewardship and the NAI approach. We begin with tort law. What is a tort? Tort is a civil, as opposed to criminal, wrong for which the law provides a remedy. There are intentional torts, such as assault, battery, trespass, and intentional infliction of emotional distress. But the most common tort that comes up in floodplain management realm is negligence. And these causes of action have their own separate elements necessary to prove the tort in court. For negligence, briefly, duty of care, which is a responsibility; breach, a failure to shoulder that responsibility; causation, that the defendant did the deed that caused the damages; and damages, some harm that the court recognizes as tortuous. But there is also a possibility of immunity. We'll discuss that a little later. Next slide. The development and widespread distribution of engineering handbooks and analytical tools by FEMA, the Army Corps of Engineers, engineering societies, and other agencies and groups are underpinning an increasingly high national standard for reasonableness. For example, in Riedling v. City of Gainesville, the Georgia Court of Appeals held there was no sovereign immunity protection for the Department of Transportation's plans for a parkway, and consequently, the DOT could be held liable for a nuisance due to placement of fill and subsequent flooding of neighboring properties. There was evidence that the plan or design for placement of fill, quote, was not prepared in substantial compliance with generally accepted engineering or design standards, close quote, at the time such plan was prepared. So let me reiterate, more and more accurate flood data is available to local governments, and with more information comes greater knowledge, foreseeability, and responsibility. Next slide. After extensive flooding and the numerous resulting insurance claims, Farmers Insurance alleged that the rainfall that happened in Chicago around the 80s was within the anticipated 100-year rainfall return frequency, or alternatively, and in the law you can argue alternative arguments, that it was within the climate change adjusted 100-year rainfall return frequency predicted by the 2008 Chicago Climate Action Plan. Farmers asserted claims of negligent maintenance liability, failure to remedy known dangerous conditions, all allegations in common law torts, and takings without just compensation, federal and state constitutional challenges. Next slide. When the case was withdrawn the following year, Farmers Insurance spokesman said, "We believe our lawsuit brought important issues to the attention of the respective cities and counties, and that our policyholders' interests will be protected by the local government going forward." While the Farmers Insurance perspective and approach to litigation was novel from the standpoint of climate change, it was based on tried and true principles of community liability and an interesting approach to defining a potentially evolving perception of a reasonable standard of care. Next slide. So at the common law, no landowner, public or private, has a right to use his land in a manner that substantially interferes in a physical sense with the use of adjacent lands. Many common law causes of action have been modified by state courts and legislatures, including various Tort Claims Act, even at the federal level. Generally, though, a nuisance is a condition or situation, such as flooding, or as in the picture above, nuisance flooding, that interferes with the use or enjoyment of property. A nuisance can arise from an act or failure to act results in interference with the use of enjoyment of property. A nuisance rises to the level of a tort when such conditions, situations, acts, or failures to act occur unreasonably. Next slide. Principal activities that increase natural hazard losses on adjacent lands and may be subject to nuisance liability include construction of roads, dams, dikes, grading, levees, other land alterations that increase flood heights and velocities on other lands, and erosion control structures, for example, groins, seawalls that increase erosion and or flooding on other lands. Next slide. Trespass is an unlawful act committed against the person or property of another, especially wrongful entry on another's real property. At common law, landowners can bring trespass actions for certain types of public and private actions that result in physical invasion of private property, such as drainage and flooding. Next slide. And finally, the law of surface water. It recognizes surface water as a common enemy of people. Hence the common enemy doctrine involving protecting your own land. Some states apply the common enemy doctrine to surface water disputes. Briefly stated, a landowner may repel surface waters as necessary, as during a flood, without having to consider the consequences to other landowners. The doctrine takes its name from the idea that floodwater is every landowner's common enemy. Simply put, everyone for themselves. Every landowner has a right to protect herself against surface waters however she chooses. Therefore, no one has a right against other landowners, and no one is liable to anyone else for causing damage by alterations to the drainage of surface water. This doctrine may promote development of land by protecting landowners from liability for altering the land in ways that change surface drainage. But it may also encourage landowners to divert surface waters in ways that most benefit themselves without considering how those actions affect other properties. Courts that apply the common enemy rule, therefore, have often qualified and modified the absolute version of the rule. Common exceptions to the general rule that someone isn't liable to others for altering surface drainage include if the alteration is intended to deflect surface water, as with ditches or pipes, and the alteration discharges more water or directs drainage in a way different from the natural drainage, if the alteration of the natural drainage is unnecessary or isn't for a reasonable purpose, and if the landowner alters the natural drainage carelessly or negligently. Next slide. So the surface water common enemy rule is the antithesis of the Gilbert-White or NAI approach to human adjustment to floodplains. And finally, sovereign immunity. This applies when citizens are suing their own state or a subdivision of the state. When determining whether a citizen may sue a state actor, someone acting on behalf of the state, like a state worker, courts will typically use one of four tests, depending on the federal and various state laws relevant to tort actions and immunity. One is the governmental versus proprietary function test. Was the actor functioning in a governmental fashion or a proprietary fashion when they made the act? If the actor was performing a proprietary function, i.e., acting for financial gain for itself or its citizens, doing something that is not historically a governmental function, doing something that can be performed by a private corporation contractor, then the state actor is subject to liability. If the actor was performing a governmental function, i.e., acting for the general public, doing something ordained by the legislature, performing an historic governmental function, then the actor is not subject to liability. Then there's ministerial versus operational, or ministerial operational versus discretionary functions and acts test. Was the actor performing a ministerial operational task or a discretionary task? If it's a ministerial or operational task, then there's not immunity. If they're performing a discretionary action, then there is. Then there's the planning versus implementational. Was the actor planning an action, or implementing an action? If the actor's planning a policy results in harm, then there's immunity. If the harm happens due to the government's implementation of the plan, then there is not immunity. And finally, non-justiciable versus justiciable. If the action is justiciable under regular court principles, in other words, if someone else doing it besides a government actor would be committing a tort, then there is no immunity. If the issue is not justiciable under regular tort principles, then there is immunity. And that's a brief overview of the common law. I'm now going to turn it over to Thomas for the exciting world of takings law.
All right, Thomas, this is Kevin. I'm just going to jump in because I'm going to stop sharing my screen, and then you'll be able to take over at that time.
Okay, thank you very much.
All right, you should be able to share your screen now.
One moment.
Sure.
User error here. Okay, thank you very much, Jerry, and thank you, Kevin, for passing this off. So I am going to jump into the world of takings law, and it's based on 12 little words in the Fifth Amendment to the U.S. Constitution, stating that nor shall private property be taken for public use without just compensation. I'm sure you've heard these words, but how many of you really feel comfortable that you understand what takings is and what it means? So what I really want to do with this part of the presentation is to provide a little background and emphasize the ultimate lesson out of all of this, which is You don't need to perfectly understand the case law or perfectly understand what takings law is. And in fact, that's a good thing because it's impossible, because the takings jurisprudence of the US Supreme Court is not a consistent logical whole that can be understood and clearly understood. So it's just a big muddle that we have to work our way through as best we can. That said, we did a pretty extensive job of covering takings in the No Adverse Impact Legal Guide. It is about 130 pages. Here's just part of that overview, and it's still not exhaustive, as there are thousands of takings cases and even more commentary on all of those takings cases. And because of the vast quantity of material, I'm only going to very briefly mention some cases in this presentation, but I would have you know that in the full NAI legal guide, there are extensive case law citations that support everything I'm going to be mentioning here. And that is the same is true of everything that Jerry was discussing as well. So it's not, we're not just saying these things. We actually have in the larger work, the specific cases that justify what we're telling you today. And again, I want to communicate that floodplain managers, if you're working effectively with legal counsel and you focus on protecting people and property, well, that you can minimize the potential liability for takings. And one final note, kind of before we really jump in, is there is different terminology that's used. So takings is kind of a very, very general term based on that language in the Fifth Amendment, that nor shall private property be taken for public use without just compensation. But you may also hear the phrase inverse condemnation. Well, inverse condemnation is a specific type of taking. It's a taking where the government has done something that essentially takes your land, but they didn't actually legally take the title to your land first and pay you compensation. So therefore, you actually have to sue the government to get paid for what they took from you. And that's why it's called inverse, because it's kind of backwards. It's condemnation going a little backwards. A regulatory taking, on the other hand, is a subset of an inverse condemnation, because if a regulation goes too far, we call that the regulatory taking. So what you get to is this idea that anytime you have a regulatory taking, that is always part of inverse condemnation. But not all inverse condemnation is a regulatory taking. Government could, for example, dump a bunch of fill on your land, or they could flood your land, and those would be inverse condemnation if they didn't first pay for it, but they wouldn't be a regulatory taking. So anyway, just to get that kind of clarified a little bit. So when we look at takings law, the only thing I'm going to discuss today is, my apologies. The only thing I'm going to discuss today is regulatory takings in the context of what we call the Penn Central analysis. Penn Central was a 1978 case that established this key three-part test that governs most regulatory takings cases. And again, I say most because there are exceptions, but those are dealt with in the NAI legal guide, and we won't touch on them today in this presentation. The Penn Central analysis basically looks at these three things. The courts are going to examine what is the economic impact of the regulation on the property owner, what were the reasonable investment-backed expectations that the property owner had, and finally, what is the nature of the government action that is being challenged by the property owner. And every one of these since 1978 has just accreted layer upon layer of different types of analysis based upon the case law. But there is a tremendous amount of case law that we identified that strongly supports the no adverse impact approach that is put forth by ASFPM. And just one little case here I can mention is Beverly Bank. And there, the Illinois Supreme Court upheld state regulations that prohibited residential structures in a regulatory floodway. And the state argued that really, look, we are protecting people from the risk of flooding. It protects first responders. It protects property owners who might otherwise be left stranded. And finally, it clearly is in the fiscal interest of the public that we are not developing in floodways because of the fact that it costs the public so much money when there is a flood. And these arguments were found to be very convincing, so there was no taking in that case, despite the claims of the property owner and the burden that they were experiencing. Maybe, and even one of my favorite cases, because it's so on point about flooding, it's about floodplain management, is Columbia Venture versus Richland County. And in this case, Richland County had a floodplain management ordinance that included standards that went well beyond NFIP minimums. And Columbia Venture had been looking at buying some land that was behind a small levee along a river. And Columbia Venture knew when they were looking at purchasing this land that Richland County was in the process of creating stricter floodplain management standards. They bought the property anyway. So in the case, the court really took the landowner, the Columbia Venture, to task, saying that they did not have any reasonable investment-backed expectations. Remember that, one of those three parts from that Penn Central test. They didn't have reasonable investment-backed expectations. The expectations they had were expressly unreasonable because they thought they were going to be able to develop in a place that was very clear when they purchased it. Richland County was in the process of putting in stricter regulations on potential development. And next, the court also, I think even more importantly, the court really leaned heavily on, quote, the nature of the government's action, unquote. Another, again, one of those three parts of the Penn Central analysis. The court said it was really important, this safety enhancing character of the government action. I like the language of the court. It said, quote, the important public purposes of mitigating the social and economic costs of flooding that are served by the city's ordinances, unquote, supported finding that there was no taking in this instance. So even though you had a property owner who now had millions of dollars that they had spent on this very large property and couldn't do any of the proposed development that they had in mind, they still said it was not a taking. Why? Because allowing it would have been so contrary to public safety. It's not all good case law, though. There are some issues that we need to be very careful of. In 2013, the US Supreme Court decided a case called Koontz. And while it was extremely complex procedurally, essentially what Koontz did is it expanded a certain subtype of takings called exactions. And exactions is basically when government somehow, in order to provide a benefit to a permit applicant, requests something in return. In the case of Koontz, they were asking for wetland mitigation or payment into a wetland mitigation fund in exchange for destruction of wetlands. What was interesting about the Koontz case is that ultimately the US Supreme Court expanded this idea of exactions from a focus on real property to allowing it to also be called an exaction when someone simply paid money to the government. Because historically, the case law was really about property rights and about being able to determine who can and can't come onto your own private property. But Koontz really expanded that. And so this has led since 2013 to a real split among courts. And the split is about, what do you do with local government programs that seek payments for different types of mitigation? So whether or not you've got a tree mitigation ordinance where people, if they cut down trees, they either have to plant, 5 trees for each one cut down, or they have to pay money into a tree mitigation fund. There are lots of different programs that operate like that. Sidewalks, trees, wetlands, a lot of different types of local government programs. And so courts are split. Does Koontz apply in those? And these are potential exactions if somebody has to pay money? Or are they different than an exaction because they are a generally applicable local government program passed by the local government? So that's something to really watch in the future and to be wary of as you're designing programs at the local level. And then there are even some what I would consider some really, really ugly cases out there. There is a series of cases. There's appellate cases in New York State and part in one of the boroughs of New York. And these cases essentially promote and reward the idea of land speculation by rewarding people for speculating on parcels that are completely wetlands, completely undevelopable, and have been defined as undevelopable wetlands for decades. And people are still speculating in some of those parcels, and the courts have given them a lot of money for that type of speculation. So it's very strange. And then another case that's still ongoing, at least in the damages portion, is the Eidecker Farm series of cases. And there it's a real lesson in, no good deed goes unpunished. The United States Army Corps of Engineers had, back in the 40s, channelized the Missouri River because the Missouri River was very, very wide, very flat, very shallow, and in the floodplain. And so when they channelized it, that allowed them to control some of the flooding on the peripheries, which of course, very, very fertile floodplain soils. So it created extremely valuable farmland. But due to an Endangered Species Act case more recently, the Corps of Engineers had to mitigate some of the harms from that channelization decades ago. This led to some increased water levels in some areas, which increased some flooding on that very valuable farmland that had been created by previous Army Corps of Engineers, taxpayer funded infrastructure. So the result now is that the court ruled this is a takings, this increased flooding from increased water levels, and so the taxpayers are again going to be paying. And ironically, the taxpayers will be paying millions of dollars to the very property owners whose property was created by the taxpayer. So that's a very challenging case, and really want to follow up on the damages session portion of that. So one of our key research findings really is this. There are almost no cases of government liability in a takings claim for a community's denial of use where the proposed use would have had substantial off-site impacts or threatened public safety. Now, there is, of course, a very dramatic departure from that I note here, but still, courts have very broadly supported restrictive regulations for high-risk flood areas based upon public safety, nuisance prevention, public trust, and other concerns. Keep foremost in your mind protecting people, protecting property. Those, I know a lot of you are also focused on environmental protection. That is a wonderful thing, and I'm very glad you're doing it. Keep doing it. But whenever it is reasonable, put front and center protection of public safety and public health, and bring the environment in as adjunct to that. Just because the language that courts have used, they make it so very clear that public safety is really the greatest thing that's going to earn you some respect from that court. Just here, a quick list of some of the ways you can help to avoid a successful takings claim based on your regulations. Make sure you're regulating to prevent a harm. To the extent you can, try to avoid interfering with the property owner's right to exclude others. Try to leave some economic uses for the property. Maybe consider transferable development rights or other options so that the land retains significant value. Make sure that if you're limiting, that there's a very close relationship between any conditions you put on a permit that you issue and any harm that was designed, that the regulatory scheme was designed to avoid. And be very, very careful if you propose some sort of conditions or try to negotiate with permit applicants. Again, that 2013 decision of the US Supreme Court, Kuntz, can make that a very, very dangerous activity, because the permit applicant could turn around and claim that what you had proposed they could do to get a permit is actually an exaction, even if you didn't write it down. And finally, this last point is important. Some of the worst things we will see for case law come when a local government tries to rush through some land use or zoning changes after there's a public outcry due to a specific project after the project or has already submitted an application for a permit under existing regulations. If you do that, you are very likely to lose, and it can create some real headaches. So try to ensure that your zoning is up to date and does not allow things that you are going to get massive public outcry against. And just at closing, I will very, very briefly say, I want to draw your attention to one portion of the NAI legal guide that I think might not be very carefully or as appreciated as some of the technical legal analysis. And that's a more wide-ranging discussion on property. And I think people may sometimes skip this over because, of course, everybody knows what property is, right? It's kind of like money. Everybody thinks they know what money is, but then you start to ask, well, define it for me. Where does it come from? How is it created? And that's what this section talks a little bit about. And so it discusses, what is property? Well, first, property is not a thing. It's not an object. Rather, property is the set of relationships amongst us as people with regards to things. And property always includes both rights and responsibilities or duties, because the duties of property are there not to limit you and your property, but to protect you and your property from other people's rights on their property. So really, property rights, I very often hear things phrased as kind of, oh, that's anti-private property rights. Well, very often it's not about being anti or pro-private property rights. It's more about which property rights are going to be most protected. And another myth about property is that it's some eternal, unchanging thing, almost as if it was, given from on high on stone tablets. No, property and the concept of property has always changed. I go through one example in the writing, but I think we're a little short on time, so I'm going to skip that here. But suffice it to say that property law is all about change. And the US Supreme Court has often noted that. Here you can see at the top from Mugler versus Kansas back in 1887. And in that case, you notice that the Supreme Court expressly allowed a local government to shut down a fertilizer plant that was operating where it had express authorization to operate. Why did they allow that? Because the land uses around it had changed. And so the fertilizer plant, quote, had become a nuisance to the community in which it was conducted, producing discomfort and often sickness among large masses of people, unquote. So as situations change, so does the law and so does our concept of property. Other examples of change here as well. Pennsylvania coal versus Mann and Keystone bituminous coal versus Benedictus. Both of these cases had very, very similar facts, almost identical facts, really, but they were separated by over 50 years. And during that time, our view of coal mining and protecting the public had changed, as had the composition of the Supreme Court. And really, the Supreme Court found a taking in the 1922 case where coal mining was causing subsidence of overlying land. But in 1987, a very similar law to prevent that harm, and the Supreme Court did not find a taking. So we really do see change in law. So some of the overarching conclusions, we have a lot of case law and it is not very clear. There is a tremendous amount of complexity around the many different factors that go into the tests and analyses that the courts use to evaluate whether or not a taking has occurred. And if you do not appreciate that extreme complexity, or your attorneys don't, it's going to be very hard for them to effectively argue your case. So it helps to go through, and in this outline for the No Adverse Impact Legal Guide, we help to break down some of what those many factors are in that complexity. But the good thing is that complexity does provide a great opportunity to very carefully frame the issues that you as local government or state government are facing and why you are doing what you're doing in a regulatory scheme work. And finally, we argue from our analyses that through good faith, careful, thoughtful regulation, really actually is very safe for a local government to engage in. If you demonstrate integrity, transparency in your regulatory processes, and you have good evidence and you can demonstrate to a court why you're doing this and what harms you're avoiding, then you may still get sued, but you're probably going to win. And finally, again, bad facts make bad law. Don't give a court bad facts by rushing through poorly thought out regulation or rushing through something to address a specific permit that would have been permitted under previous regulations. Those are just the kind of bad facts that courts are going to rule against you on. So avoid those. And with that, I would like to say thank you for all of you for signing in, and we look forward to questions.
Thanks very much, Thomas. So we do have a few questions that I'm going to kind of open up to the broader group here, and we'll just start kind of at the top. So early on, Susan was asking if there are any regulatory definitions of adverse impact, from other agencies, and she mentioned, FHWA does not have a regulatory definition of adverse impact, but thought I'd ask you all as presenters if there are any that you're aware of.
I don't know if Jerry or Janet or Terry want to jump in. What I would say is I know that sometimes at the state level, you've got agencies within the state that may have definitions of adverse impact. I know from my previous work in Florida, there's the water management districts have specific definitions, but even those are not always very easy to apply in any given factual situation. So the standard may exist in some cases, but even then it's, again, the same challenge courts have. You have to take a specific standard that's been articulated and then apply it to facts. And that can be challenging.
Yeah, I would say from a tort perspective that the courts use the term adverse impacts, but I'm not aware of any definition, at least nationwide. Certainly there probably are in your various states.
Okay, great. Thank you, Jerry and Thomas, for that insight there. Next question is from Matt with, I don't know, maybe a little bit of a law school style hypothetical here, but we'll see. So he's saying, if a city channelizes flood flows through its borders and that results in increasing flooding to a city downstream, would that city be in violation of the law of surface water?
Potentially, it depends what state you're in. The law of surface water is a minority approach. There may be other liability, though, as opposed to the law of surface water. It's an adverse impact external to the operation, and there's probably state litigation that would be involved.
Okay, yeah, absolutely. Thank you.
Yeah, Kevin, this is Terry.
Please,
I
Terry,
will
yes, please.
say, and y'all forgive me, I have no clue what happened except Zoom booted me, but I'm back. Did want to say that impacts are now more easily definable, and when I say that, it's a lot easier now to, and every day that we proceed with technology, that impacts are more easily defined and measurable. And so those are the type of factual things you would bring to court in a court case. So I'm going to say that if from a matter of fact standpoint, if a downstream neighbor could point to the upstream neighbor as doing something, and then would be able to measure those impacts downstream, I agree that maybe there could be an issue worthy of finding yourself in court. But again, I'm not the attorney. Thomas and Jerry are.
Yes, but you make a very great point, Terry. And ultimately, I mean, obviously, Jerry is right. each state has its own laws. And what we discovered is there are states where the hypothetical given, there are states where it would be a lot easier to make the case that that upstream local government that channelized the waterway is liable. And there are others where it tends to be a lot more difficult. But that's where what Terry said, or excuse me, yeah, what Terry said really comes into play, which is what is the level of evidence you can provide? And, but again, there are states that sometimes they make it almost impossible to sue a local government for what they're doing with their water management. And there are other states where it's quite easy, actually. And really local government gets very little extra protection from what they do from a water management perspective compared to private property owners. So again, we can't really say, because you need a lot more detail in the factual situation, and you need to position that hypothetical in the law of a specific state.
Okay, thanks, Thomas. Thank you, Terry, as well for weighing in there. Really appreciate it. Before we get to the next question, Thomas, would you mind stopping your screen share? I want to pull up a slide from earlier on that I have up. Thank you so much. And so this question is dealing with the governmental immunity segment of the presentation. And so Jerry, this person is just saying, I'm not sure if I was quite keeping up, but governmental immunity in this context is valid for the following: governmental function, discretionary function, planning, and justiciable, and then no immunity for the following: proprietary, ministerial, operational, implementation, and non-justiciable. Is that right, or did I mix that up?
No, I think you got it right.
Okay, good. Thank you. Just wanted to clarify, and I wanted the slide up on screen just so we could all see that together. Next question. Brian's asking, when a local government allows fill in the floodplain and others are adversely impacted, that is an inverse condemnation? Is that right? Is that how it's described?
It could potentially be an inverse condemnation. It could also be tortious as well.
Mm-hmm.
It could be a tort. But again, it's going to depend heavily on the specific facts of the situation. The takings claim might not depend as much on state law, although state law can still have an impact on a takings claim. But the state law is going to be really important in whether or not there's going to be a liability from a tort perspective for allowing fill that subsequently increases flood elevations for others.
Okay, yeah, that definitely makes sense. Okay, so just a comment from Deb here. She's saying this is exactly what we're going through on the coast, especially with high demand, high dollar development. So definitely some real world impacts here. But Alexander had the next question, wondering, is there any legal issue with quote special basin criteria, and that is having areas within a community with more stringent drainage or floodplain regulations? For example, could you have one sub-basin in a watershed where you require a developer to provide more floodplain storage, for instance?
If
I
I
think
could take that one, and then maybe the guys could answer from a legal perspective. When we did it in our community, we had to justify why we did it. So we had 2 basins that we required an additional 10% of storage. And we had to, when we did that in the materials we presented to council before they voted, we had to actually justify, and this came from our legal counsel, why we were doing what we were doing. And basically it was for the protection of public health, safety, and welfare, which is in our charter. And so I'll let the guys go from here, but I know we had to justify why we were doing what we were doing.
Yeah, I think you want to be able to scientifically demonstrate the risk of the harm that you're trying to avoid and make a reasonable regulation to address that risk.
All right, very good. Thank you. Kristen has a question here. Are you able to expound at all upon the language, quote, good faith, careful, that paragraph in one of the last slides as it applies to, do not propose anything or negotiate with permit applicants? Um, just wondering if there's any clarity around the good faith, careful language, I guess, is the crux of her question.
Yeah, I really hate to have to add that in, but that 2013 case from Kuntz is very challenging because there, the state agency in the state of Florida that resulted with liability because the Supreme Court found that they had tried to exact something from the property owner. What they were doing in that situation is the property owner had come in and proposed a development that destroyed a number of acres of wetlands on their property. And the water management district has sat down with them and started talking with them and said, look, you got a lot of options. We're not going to let you, our regulations won't allow you to destroy that much of the wetlands on your property, but there are ways we can work with you. And they said, you can either put more of your property into a perpetual conservation easement to protect it, and then we can allow you to, impact this amount of wetlands. Or if you're unwilling to do that, you can pay into this wetland mitigation fund where we will, acquire additional wetlands to protect in the same water basin. They had a number of different options. The property owner didn't like any of them. And the water management district never issued a permit, never said, they never issued the permit. And yet the court still managed to find that the water management district, by the sheer act of suggesting these options that the property owner had effectively tried to exact something from the property owner, even though the property owner rejected any of the options. And that really left the water management district merely applying its regulatory criteria. So it's really hard to draw any conclusion from that case other than the fact that even when you're trying to negotiate in good faith with a permit applicant, that if you're negotiating, you're potentially opening yourself up to legal liability. If the water management district in that case had not discussed options with the permit applicant, I think I feel fairly confident in saying there's an extremely low likelihood that the permit applicant would have won any sort of takings case, because it would have been a takings case under that 3-part Penn Central analysis, which you have to meet a very high burden to find a taking under that analysis.
And Kuntz is a really procedurally problematic case too. The takeaway for me is if you want to regulate, have a regulation.
Yes, I think what Jerry is getting at there is have a clear regulation as opposed to having a program that allows, conditional, that relies very, very heavily on conditions and negotiating and giving permit applicants space to be creative. That's unfortunately, while that may be a great idea, and we may think that personally that's a great idea, this case has made it legally more problematic than it probably should be.
Yeah, and we may have done it in land use regulation for years, but that type of flexibility needs to be built into the statute or the regulation at issue. It can't be something that staff is doing off the top of their head, so to speak, or that it would appear that way to the court.
Yeah, that's helpful. Thank you, Jerry and Thomas. Got a question here from Alexandria. Another clarification about the immunity tests. So she's asking, could you provide an example, something that sort of illustrates the differences between a ministerial or operational function versus discretionary function?
Yeah, ministerial would be like the issuing of a permit. and discretionary would be, you know, the provision of a service that isn't quantified.
Yeah, I guess I can give one that's kind of concrete as well, or asphalt in this case, maybe. Look at roads. You know, roads, you have a ministerial duty to maintain them, essentially, like if there are big potholes or the striping is gone, it's worn out, and you don't restripe or you don't fix that pothole, and then somebody has an accident because of that, then you're probably not going to have any sovereign immunity, because the court's going to say, well, you got a ministerial duty to do that. It's not. Whereas if you're talking about whether or not to, say, take a 2-lane road that's heavily over trafficked and turn it into a 4-lane road, now that is not a ministerial duty. Even if the 2-lane road has way more traffic that can handle, the court is still going to look upon that major difficulty of converting that into a 4-lane, not as just something that staff can decide, but that's something that the local government, because of the incredible expense and difficulty of doing it, you know, acquiring more right of way, the construction, that's going to be more of a legislative or policy decision, as opposed to just something that you should have procedures in place at the staff level to make sure it happens and stay safe.
Great. Okay, thank you. Got a question here based on something Terry said earlier, comment on the impact of technology on measuring impacts, but what is the likelihood of enhanced legal awareness of anticipated adverse impacts given projected regional and localized impacts on floodplain from climate change? Are the courts prepared to assess something like that?
Are they prepared? I don't know. Are they going to have to deal with it? Yes. And I think, again, as more information comes to light, as these cases are brought to court and those things are memorialized via cases, I think more and more the courts are going to have to become knowledgeable whether they want to or not.
I think that's a great response, Terry. And I will share that Jerry and I have discussed at length that this really is one of the key issues in a future chapter for another edition of the No Adverse Impact Legal Guide. Is really, it's kind of a mix of, you know, what do projections mean and what we call attribution science, or just the science of attributing to climate change, how much climate change is responsible either for the likelihood or severity of different events. But yes, these are issues that are already starting to come up in court. And do we have clear, consistent rules for how to address that yet? Absolutely not. But we are going to work on that, because clearly everybody understands that we've been driving by looking in the rearview mirror. And while that might have worked as long as the road was straight in front of you, there are some curves coming our way that we're hitting, and we can't be looking backwards anymore to go ahead.
Yep, that makes a lot of sense. Thanks, Terry. Thanks, Thomas.
But
Yeah,
at
go
the
ahead.
same time, Thomas, the rearview mirror provides the foundation for all of the findings and information we're now learning. And so they're building on that, you know, the data, for instance, from hurricanes and tropical storms, and being able to look at the severity of storms, the intensity of storms, the frequency of storms. We have all that data, and we are looking at it both present day, but based on the past. And you know, the information that's coming to light is pretty impressive. And I think we're going to see more and more cases in the courts based on climate and climate adaptation or lack thereof.
Yes, and I think that relates very much to this idea that our evidence is from the past, but until we are actively incorporating projections of our future into our regulatory schemes, I think that's still a dramatic weakness. Of course, Congress required, starting over 10 years ago, over a decade ago, told FEMA to add climate science and the best climate science projections into the national flood insurance mapping, and it still hasn't happened. So we are still kind of looking too much just to past. And I think evidence of that is, of course, I have to be careful saying this because some statistician will tell me how wrong this idea is. But essentially, we have lots of examples nowadays of places where you have seen numerous 100-year storms, even 500-year storms in the span of just a few years. You'll see several instances. And while I know that's theoretically possible, it's becoming more and more unlikely that it's just chance that we're having so many 100-year and 500-year events in so many places in such short time periods. It begins to defy the odds. And that means that our whole concept of what we think we know from past evidence about what is a 100-year event or a 500-year event is simply wrong at this point.
Okay. Yeah. Thank you. Thank you both for that very thorough response. That's a good question. Rowan has a question here. I'm going to attempt it. It's a little bit lengthy, but I know Rowan spent a lot of time on it, so I want to see if we can get an answer to this. So just bear with me a moment. This presentation so far has generally focused on how NAI is legally defensible, where it results in a more restrictive approach to floodplain management. Modern floodplain restoration work often seeks to actually raise flood profiles where it's safe to do so, but where these activities intersect with mapped SFHA's restoration activities are constrained by the NFIP. Projects that have NAI are still saddled with an obligation to either show no rise, which often hamstrings the quality of the restoration, or spend significant additional funds and schedule to undergo a CLOMR. Is there a precedent for demonstrating NAI in lieu of no rise for implementation of higher quality floodplain management that adds capacity to attenuate and store floodwaters where it is safe to do so?
Janet, you want to take that one? I'm still processing the question.
Yeah. There's a lot of detail. We can also maybe follow up with Rowan via
yeah,
email.
and Rowan, we would be glad to. What I didn't hear in the question is one of the offsets is mitigation. So that might be a part of the answer, but I really would love to study that one before Janet and I answer you, unless Janet's totally prepared to take this one.
No, there's a lot of controversy and there have been different takes and different interpretations in different areas. So
yeah, absolutely.
It's a difficult issue.
Yeah, absolutely. We can definitely address that one maybe in a follow-up. Okay, next question. Joseph is saying FEMA allows for increases in floodplain elevations within regulations so long as it is contained within the requester's property. How does that play into no adverse impact? Or does it, I guess?
I am going to give the example of a glass of water that is only half full. If you put enough ice cubes into that glass of water, it's going to spill out all around the glass, onto the table, onto the floor. Mother Nature and flood boundaries don't read maps, and nor do they have any respect for property lines. So I think, and this is just a personal take on this here, it is very hard to confine adverse impacts onto a single property unless that property is extremely large. I think there can be unintended or unexpected adverse impacts, but more often than not, those impacts, if they're not mitigated, will not stay wholly on a single piece of property.
All right. Very good. Thank you, Terry. We've got a few more questions here. In fact, we've got almost 24 questions outstanding. So I think what we'll do is maybe take one more and then we'll close. And then what we're going to do is try to answer some of these questions. We may consolidate some or what have you, but we may try to answer some of these kind of in writing and then distribute some of those answers along with the rest of the promise follow-up here. So just to close, Steve had asked, or rather said, some communities are beginning to say that no adverse impact and NAI as also no impact and will deny a project even when channel improvements have a slight decrease in WS elevations locally. Any thoughts on this interpretation as it comes to denying projects within a floodway from a legal standpoint?
I'm sorry, Kevin, could you repeat that question, please?
Yeah, yes, and there may be, I may be transposing an as for an and or something, so it's not quite making sense. But I think the thrust of Steve's question here is that communities are beginning to say that NAI, I'll just read it how it's written. NAI as also a no impact will deny a project even when channel improvements have a slight decrease in WS elevations locally. Any thoughts on this interpretation as it comes to denying projects within the floodway from a legal standpoint? So maybe not a great question to close on if there's a typo or something there, but
Well, we've seen courts uphold regulations denying any development within the floodway, but it was clearly in the floodplain regulations of the community, and so the property owner was on notice.
Yeah, I'm not sure I understand the question well. I'm not sure I'm confident enough in my understanding of the question to provide an answer.
yeah, that's okay. I'll go ahead and reach out to Steve, and again, we can see if we can get that one clarified between him and I, and then maybe I can pass that along for a little bit more of an answer. But as I said, we're just about out of time here, and so to close, I just want to reiterate a few things I mentioned up at the top, which is related to credits and certificates of attendance and all that. So again, this presentation is eligible for floodplain managers and planners if you're a planner to get credit for this, and we'll be issuing certificates of attendance to you. I'll be emailing those out to you, so you can look for an email from me, Kevin at ASFPM. That'll come to you in about a week, and that'll have some of the materials from the presentation today. Definitely your certificate of attendance, potentially the recording. We may have the slides available to you as a PDF. We'll certainly endeavor to answer many of the outstanding questions, or as many as we can here, and distribute those to the wider group as well. So all that follow-up will be coming to you, as I say, in about a week. So please just be patient on that front. Beyond that, certainly want to thank all of our presenters, Terry, Thomas, Jerry, Janet. Special shout out to Janet for kind of picking up in the middle when she wasn't expecting to present. I know that can be a little bit dicey. So thank you very much, Janet. That was super seamless. And then to all of you who attended and joined us this afternoon, thank you to all of you as well. We'll be following up with you, but otherwise, that's all we have for you today. So thank you so much, everybody. Have a good rest of your week.
Bye, everybody.